So we need to talk about a critical case the Supreme Court has recently agreed to hear that could completely reshape the Fourth Amendment in this digital age. This case asks a very simple but extremely dangerous and important question. Can the government use a single warrant to identify every person in a location all at once, even if they have no idea who the suspect actually is? The Supreme Court will now hear arguments in this case at the end of April, and the outcome of this case could actually be one of the biggest Fourth Amendment rulings that we've had in a long time, especially in this current digital age. And this is going to impact everyone who has phones, uses Google, or really any online services. So let's break down what is happening in this critical case. Now, before we jump into this video, I want to thank the sponsor of this video, which is TacPack. TacPack is a subscription-based box that delivers gear to your front door every single month. And right now, TacPack is doing something special. The next TacPack Plus box features a lot of new products. And if you sign up using my code ARMED, you can get a free $60 tactical gift with your new subscription of the TacPack box. So if you've been interested in TacPack for a while, this is the month to jump in so you get those additional free gifts and that additional value. Just remember when you actually sign up to use the code ARMED to get that additional tactical gift and to get all those additional perks that TacPack is offering to my viewers. Now, as I mentioned in the intro, in this video, we're going to be discussing a critical Fourth Amendment case that will be argued in front of the Supreme Court in just a few weeks. This case involves the Fourth Amendment and our rights in a digital age, and if we, as users of these products and services, have actually given up our rights, by using those types of products. This case specifically centers on something called a geofence warrant. And here's what that means in plain English. Instead of investigating a specific suspect, law enforcement has the ability to go to a company like Google and say, give us all the data on everyone who is at a certain area or within this geofence location at this certain time. They don't identify just one person. They don't identify maybe a known suspect. They just say, give us all this information for this general area for this specific time period. And that's what happened in this case called US versus Chattree. This is the case that has made its way to the Supreme Court, in which they will hear arguments on and ultimately rule on. In this case, police were investigating a bank robbery, but were unable to identify who committed the crime, and they really had no leads or any suspect. So they went to Google and requested some location data for every device and every person that was within this location during the time of the robbery. That initial search pulled a pool of completely unknown individuals. Then, and essentially this is critical, law enforcement decided to narrow down that pool step by step by requesting additional information on those users that Google provided. And eventually that led them to identifying this one defendant here in this case. And based on that, in that whole process, he was convicted of the robbery. Now, here's where things get serious. This wasn't just a targeted warrant. According to the petition, this process required Google to effectively scan through massive amounts of user data to identify devices in that area. We're talking about potentially hundreds of millions of accounts being searched indirectly just to generate that initial list. And that's why this case has raised alarm bells across various courts, because this starts to look less like a traditional warrant and more like just a general digital warrant that is being served to a company like Google, and then they're going through all this information. And the lower courts are all over the place on this specific issue. The Fourth Circuit in this case ultimately upheld the conviction, but did so in a fractured decision with multiple opinions. The Fourth Circuit found that the geofencing process violated the Fourth Amendment, but they ruled against Mr. Chattree here, excluding the evidence based on the good faith exception. So the good faith exception is a legal doctrine allowing evidence obtained in violation of the Fourth Amendment rights to be admitted to a trial if law enforcement acted with a reasonable and good faith belief that their actions were lawful. So it was that exception that got this information in, but generally the Fourth Circuit found that this type of general geofencing warrant was not permissible. At the same time, other courts like the Fifth Circuit have gone the exact opposite direction and said that these kinds of warrants are unconstitutional. So now you have a direct conflict, and that's exactly why the Supreme Court has stepped in on this issue. The Supreme Court has officially granted review in this case, and it will be argued in front of them on April 27th. But they did something very specific in this case. When they granted review, they limited review in this case to just question one, and that is whether the use of the geofencing warrant violated the Fourth Amendment. That means that the Supreme Court is not deciding the exclusionary rule or the good faith exception that the Fourth Circuit used to keep this evidence in, or essentially what happens to the conviction of this individual. The case is focused on one thing. Is this type of surveillance constitutional at all, or should this type of process be struck down as unconstitutional? So this case is not just about this one incident, it's about what rights we all have because we use services like Google and other products. It's about whether the government can identify everyone at a protest, everyone at a church, everyone at a political event, and just search a general area without us ever even knowing what's going on, or that we're even being, targeted, or our information is being given out. And this in many ways kind of flips the entire concept of the Fourth Amendment on its head. So at its core, the court is deciding between two very different views of the Constitution. So the first view is kind of the whole government position here, which is that this is just business records. People voluntarily share their data with Google, so there's no Fourth Amendment problem. Now, the other view is really just the privacy rights, argument, the constitutional argument, and, really the defense's position as well. Essentially, they argue that this is mass surveillance. The government is searching everyone first and then figuring out after the fact probable cause to identify an individual and get that information. Now, as we get closer to the April 27th arguments, here are some key things that we're going to be watching for and listening for during those oral arguments. So first, listen for the phrase general warrant during those arguments. If multiple justices use that language, that's a huge warning sign for the government itself, and it may signal that the Supreme Court is leaning away from their arguments and is going to rule against them. Second, watch for how the judges talk about everyone versus a specific suspect warrant. That distinction may likely decide this case. The court will be asking, is this warrant targeting a suspect or a warrant targeting everyone? Also, listen for discussions about whether geofence warrants constitute searches under the Fourth Amendment, and because especially lower courts are very deeply split on that issue of whether this is even a search. And third, listen for the reference to a case called Carpenter versus the United States. In Carpenter, the court said that you can't track someone's movements over time without a warrant, even if that data is held by a third party. Now, here's why that matters. The defense here in this case during the arguments is going to argue that the geofence warrants are even more invasive than what Carpenter considered, because instead of tracking one person, they are actually capturing everyone in a location, and they have this information not just for a limited time period, but essentially forever. The biggest takeaway right now is this case has the potential to become the most important kind of digital privacy case that we've seen since Carpenter, and I believe that was decided back in 2018. And unlike most cases, in my opinion, this is not going to break cleanly along liberal versus conservative lines. This is going to come down to, how do some of the judges view technology, privacy, and the limits of government power. So I think we're going to see a very strange block of justices on this opinion depending on which way they go. So now all eyes will turn to the April 27th oral arguments, because what happens in that courtroom could determine how far the government can actually go in tracking your movements without you ever knowing. Also, it will help to kind of shape the Fourth Amendment in a digital age where we all use technology and services on a daily basis. So the question really does become, does the Supreme Court believe we have voided our own Fourth Amendment rights just by opting into these services? So we're going to find out really soon what the Supreme Court believes on this issue. So as this develops more, as we get more information, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply by liking, commenting, and subscribing. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this type of content, and so it shares it with more people. But as always, thank you so much for all of your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.